All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near. Give attention. You will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is number 23-0682, advisory opinion to the Attorney General Ray, adult personal use of marijuana.
Mr. Chief Justice, and may it please the Court, we're here this morning on the Attorney General's petition for an advisory.
I'm having trouble hearing you. I'm sorry.
I apologize. Well, we're here this morning on the Attorney General's petition for an advisory opinion on the adult personal use of marijuana amendment. I'll speak first for the Attorney General. I'm joined by counsel for the Florida Chamber of Commerce, Sam Salario, and we will split our time and are each requesting 2 minutes for rebuttal. And then you'll also hear from Mr. Bash for the sponsor. One of the most consequential choices that a voter can make is whether or not to amend the Florida Constitution. And that's why the truth in packaging requirements of Section 101.161 are so critical to ensuring that voters make an informed choice and provide their informed consent. And what the statute requires is clear and unambiguous ballot language and a ballot summary that is an explanatory statement of the chief purpose of the measure. The Attorney General opposes ballot placement because we think in several ways this ballot summary is misleading. And I'd like to start this morning with what we think is the most straightforward and uncontroversial of those ways, which is the ballot summary's discussion of other state licensed entities. In a series of recent cases, this court has said that when a ballot summary promises that a proposed amendment will do something, and the amendment itself does not do that.
How do you read those words to be a promise?
Because the word allows, Your Honor, suggests, like with the very first line, allows people over 21 to possess marijuana, that there would be, in fact, as a direct result of the amendment, other state licensed entities.
I guess my question, though, is the words are, and other state licensed entities.
Right.
I don't see help me understand what is promised as a result of those words. What will happen? What is the promise that the voter, you say, is misled by?
What the summary suggests is that post-ratification, there will be an availability of licenses.
May license. You'd have no problem with that language.
That would be less problematic, although I do think it's worth noting that, as we say in our brief, that really is not even the effect of the proposed amendment, because all that the proposed amendment would do, it doesn't change anything about existing Florida law or about existing Article 10, Section 29. Today, if the legislature wanted to, it could provide that additional licensure as a matter of its ordinary police powers, and because Article 10, Section 29 right now allows consistent legislation. And I think what's really going on here is that the ballot summary is playing on a desire of voters to see greater competition in this marketplace, because there have been public complaints that the marketplace is monopolized and thereby raising prices. And so voters, at least some voters, may well find it to be significant that there will now be an availability of other licenses, when in fact we know that that's really not what will happen. To the extent that this proposed amendment has any effect at all, it would only be in allowing these other entities that would like to be licensed to go and lobby the legislature. And then the legislature would have to decide if the licenses should exist. And I'd like to highlight two.
I'm sorry to interrupt you, though, but so it seems like I agree with you that in one sense you could argue that in the substantive language here itself, not in the summary, that this thing about allowing the legislature to license entities isn't really doing any work. But I mean, it seems like in the absence of something like that, in a future case, if the legislature did try to do that, someone would inevitably come in and say, this talks, the amendment talked about the medical marijuana treatment centers, and therefore this was meant to be kind of a comprehensive thing, and by negative implication, no one else can do it. So
Right.
it seems like it wasn't an unreasonable choice to put that in the substantive part of this itself. And so to then expect the sponsors to go into this kind of convoluted explanation in the summary, given that the baseline here is, chief purpose is the target, it just seems like I don't know how reasonable that is.
Chief Justice Muniz, one way or another, there's a problem with the ballot summary because it is saying that the amendment itself does the allowing, when that's not at all what's going on. I mean, I think what they could have said that would have been less problematic is simply that the proposed amendment would preserve the legislature's pre-existing authority. So at a minimum,
that's getting really. And I understand if we're having kind of a super lawyerly discussion about it, I understand that. But we're talking about, a ballot summary, 75 words, chief purpose, material, material effects have to be disclosed. I mean, if you read it literally, what it's telling people is that there might be 2 entities in the state licensed other than these medical marijuana treatment centers that, if you want to read it literally and ask, what is this telling people? I mean, is that really relevant to the overall competitive landscape? There could be 2, there could be 1,000, but you know what I'm saying? If we're going to parse it like that, isn't that really what we're talking about?
Well, we don't understand the word allows that way. So look at context. That first sentence of the ballot summary is quite clear that the amendment would, and we think this is misleading, but it says that it would allow the possession and use of marijuana, the recreational possession and use. Allows is being understood by voters in a very particular way in the context of this ballot summary, that the amendment itself would generate some rights, including the right to apply for licensure, I think most reasonable voters would assume. But I'll just highlight 2 cases and then move to our next argument. In 2021 and 2020, the court decided a couple of cases that I think are very similar to here. In 2021, it was the regulate marijuana like alcohol case. The ballot summary there spoke in terms of the amendment regulating for limited use, recreational marijuana for limited use. And so the court asked, well, is there anything in the proposed amendment itself that actually imposes a limit on the use? And of course there wasn't, and so the court found that the ballot summary was misleading. And similarly, in the competitive energy market case the year before that Regulate relied on, the court found that language in a ballot summary purporting to create a right to sell electricity back to the grid was misleading because at most what the amendment would do would not limit a right to sell energy back, and it would just leave it to the legislature to decide whether to create that right. And I think that's more or less on all fours here, because what this amendment would actually do would simply leave it to the legislature to decide the licensure point.
Can you tell me though, can you just sort of quickly, and I know you want to get to your other stuff, but just quickly walk through the thought process of a voter to whom this distinction that you're raising would be material? So I'm in there, and I think the idea of allowing recreational use is good, but I would vote no because the legislature might not authorize entities other than MMTCs to sell. I mean, who are you trying to protect?
Well, I think that Section 101.161 is clear, that we need clear and unambiguous language. And so even if I can't necessarily identify the hypothetical voter, I still think if a voter would believe the contrary of what the amendment actually does, that's reason enough alone, even if maybe it's not necessarily changing anybody's vote. But I do think probably there's some subset of voters that's sort of apathetic about recreational marijuana use, has no interest in using it themselves, but they would like to see more competition in the marketplace, and so they'll support it under the idea that this will lower prices. They oppose monopolies, and so they want more competition in the market. I'll turn next, though, to our argument about federal law. which proceeds basically in 2 steps. The starting point is that right off the jump, the sponsor has injected uncertainty and confusion about the interplay between the proposed amendment and federal law.
Is that an injection, or is that just reality? There is, in fact, confusion. I mean, the federal government has done itself, I would say, very little to clarify its position, right?
I think yes, I think that it is a very easy circumstance for voters to be confused about this, both because of the Department of Justice's conflicting stances on this, also because of the sponsor's own affirmative statements to voters, but also because, just as a matter of common understanding, I mean, if you drive around the city of Tallahassee, you cannot help but pass any number of marijuana dispensaries. And it's just sort of a very unusual and maybe unprecedented
So help me
circumstance.
understand what this does to inject confusion.
Because it uses a word, allows, that affirmatively
Well,
suggests.
yeah, but come on. It also says applies to Florida law. I mean, like, we can't not read the context of the whole statement, right? And you know, last year we agreed with that argument because the ball was hidden. Where's the hidden ball? It says on the face of this that it applies to Florida law.
Right. So, and I see my time's expired.
It says it does not immunize violations of federal law.
So I understand. I'd point you, okay, so that's the first step. They get the ball rolling on the wrong foot because of allows. The second step is that because of that confusion, they really do have to point you to some place in the ballot summary that clarifies. So Your Honor has identified the bit about not immunizing violations of federal law. But I would point you to Justice Kennedy's dissent in the 2014 case, because what he pointed out there.
That's a totally different word. That was authorized. That was different. Totally different.
That is true, but
and I had a different view when this terminology was used. You probably remember.
Well, yeah. It's sort of.
I say that only because you mentioned my name.
We obviously don't know what was in the justice's mind in 2015. That was a case that wasn't briefed and argued. But we've racked our brains to try to figure out what the difference between authorized and immunized would be. And if you just substituted the words in to Your Honor's opinion in 2014, what a reasonable voter might believe from that caveat was that and I'm quoting from page 821 of that opinion, just substituting the verb, what the conduct immunized by the proposed amendment would not be conduct that was illegal under federal law. It's the same analytical move, and I think there is at least ambiguity in this ballot summary that a reasonable voter could look to and think this will not be criminal under federal law, or at least there will be some
I don't know how a
subset.
voter could, when it says it does not immunize violations of federal law, how a voter could be confused by that. I'm baffled by the argument.
Chief,
Maybe it's just me.
may I ask a question? Okay. I know your time you're running into it here, but let me ask one question. What language is appropriate?
So I think that what sponsors should do is try to parrot as close as they can, while also explaining the language in the proposed amendment itself. Now, they've chosen allows because it's much more appealing to voters to vote for something that actually does something. It allows something. What they should probably have said is that the amendment eliminates state law penalties and liability for certain uses of marijuana. That's far more accurate. Now, they don't want to do that because, well, it's just less sexy, less appealing to voters. But that's probably the language that they should be using.
Thank you. You can still have a minute and a half for rebuttal.
Thank you.
Good morning. May it please the court. My name is Samuel Solario. I'm here for the Florida Chamber of Commerce from Lawson Hutt Gonzalez. The Chamber is interested in this amendment because it's advocated for the principles that our foundational document, the Constitution, is not the place for impulsive policy change, that legislation on tough questions is the constitutional province of the legislature, and that under our constitutional structure, Citizen initiatives are reserved for singular changes susceptible of a single up or down vote. This amendment fails under those measures. The amendment makes two fundamental changes in our organic law. One is to immunize from legal sanction the adult recreational use of marijuana, but it accomplishes a second objective, which is not disclosed in the ballot summary, and that is to give medical marijuana treatment centers effective regulatory capture over a commercial market. The initiative creates a commercial market for recreational marijuana. It grants existing medical marijuana treatment centers an immediate and effective oligopoly over the distribution of recreational marijuana. It defers to a later date whether, if ever, medical marijuana treatment centers will have competition from other market participants. And it, at least in the near term, forecloses and at least creates substantial doubt over personal cultivation of marijuana for personal use. So I
Help
want
us
to
understand under this argument what a oneness of purpose means. If a measure is to have a oneness of purpose under our case law, does that mean that it can never, with one change to the organic law of the state, both permit something or remove penalties for something without speaking to the market implications of it?
I'm not suggesting that, and I'm going to suggest two approaches to how you deal with the single subject requirement, and I think it's entirely dependent on your inclination. But I think the first is to look to your existing oneness of purpose test and the most applicable precedents. And listen, I'm not going to pretend that I can divine a single rule that harmonizes every single subject case in the
We
court's
can't.
jurisprudence.
We haven't, so I can't ask you to do it.
But what I will say is where an amendment like this one does multiple things, I think the approach that is consistent with the most applicable precedents and that makes the most sense is to ask two questions. First, what is the main thing that the amendment does? And then two, or second, are the secondary things that the amendment does the result of direct inference from that first thing?
My trouble with that is Marcy's law. You know, if you look at what that amendment to the Constitution did, it both, you know, created substantive rights, or didn't create. It said that it would protect substantive rights on the part of crime victims, and then went to some length to talk about what those rights entailed. It doesn't seem to me to be all that different. I don't remember the chamber or anyone else arguing that Marcy's law suffered from a oneness of purpose problem.
And I'm not going to pretend that I'm familiar with every jot and tittle of Marcy's law, so I may be.
Well, but that I guess that goes to the one point you're making, which is it's very hard to be familiar with every jot and tittle of a 40,000 word Constitution as opposed to a 9,000 word U.S. Constitution. And
of course, Marcy's law came through the constitutional revision process,
also
correct?
a significant distinction.
Right.
But I
which
guess
just doesn't have the requirement.
focusing on the idea that there be some analytical unity of purpose to each amendment to the Constitution, I wonder what passes if we agree with you that this one is problematic.
Well, I think we can give you some examples both from the cases on which we rely and the cases on which the sponsor relies, okay? So I think if you look at cases like Nonpartisan Commission or Save Our Everglades or even Fine, what you will see is kind of an aggregation of provisions that somebody may have thought was a good idea and at some level of abstraction might have had some relationship, but were not directly connected by inference. So look at Nonpartisan Commission, right? The primary thing that amendment did was to create a redistricting commission. Now, it also required single-member legislative districts. There is nothing about the creation of a nonpartisan districting commission that necessarily implies that you would have single-member legislative districts. And that implicated the log rolling concerns that troubled the court and that were ultimately the reason, standing alone, that the court in that case determined the thing violated single subject. Look at Save Our Everglades. The primary thing that amendment did was to provide for Everglades restoration. Now, it also provided that the sugar industry would have to pay for it. And you might say at some level of abstraction, right if you're going to restore the Everglades, the money's got to come from someplace. But having the sugar industry pay for it, we're not so closely related. One was not the direct inference from the other that the court said both on log rolling and on multiple functions of government grounds that thing failed the test. Fine is kind of similar, right?
Why would we not look through the lens, somewhat of a disunity lens, more thinking about oneness of purpose, if we're looking at it historically from a log rolling perspective? Log rolling would have been understood as unrelated topics that would each garner minority support rolled into one bill to garner a majority. Why in this case would we not look at it from a disunity perspective? It's related, right? It may not necessarily be to your kind of necessary consequence test, but why is that not an issue for the voter, whether if they want to authorize non-medical use of marijuana, they get to also consider whether or not they want to vote for this bill or this constitutional amendment, considering the licensing issues and that other sort of thing. Why would it not be an issue for the voter rather than a oneness of purpose issue?
Well, I think if I understand Your Honor's question, I think you're right, and I do think that the disunity here, like when you think about log rolling, I think it's a useful test for determining, or a useful kind of indicator of whether something violates single subject. And here you would think, listen, I think that you can easily conceive of a voter who would think that I'm in support of decriminalizing recreational marijuana, right? I'm a libertarian. I think it's a relatively harmless personal vice. I don't really care what people do in the privacy of their own home.
I guess, but if it's still topically related, we kind of have two issues. We have one, whether it meets the single subject requirement.
I see what you're
And then we have, this is kind of like to the sponsor's detriment or whatever. If they're going to create a proposed constitutional amendment that touches on so many various consequences
I get it.
of the broader topic, that is something kind of, they take on that burden of convincing the voter that all of this is good, whereas it still touches on a single topic.
So
for the purposes of the test. Why shouldn't we view it through that lens?
I think a few points on that. One is just to kind of go back to kind of the context and history of the single subject rule, right? It stands alone in our Constitution among methods for amendment in that it is not subject to public hearing and debate. It is not subject to the negotiation and compromise that is reflected in legislation. It's not subject to the kind of fine pen drafting and editing.
But of course, we have a single subject requirement for legislation. I'm not following this.
Well, except the single subject requirement for legislation, I would argue, and frankly, this court held in fine, is both textually and contextually different, right? The single subject requirement.
A little different. Looks pretty similar.
Well, I think properly and directly imply two very different things. I mean, directly implies a close connection. Properly applies.
Well, could I go back to what you started off with? I mean, your fundamental position here is that this is just not a proper subject for the initiative process. It's a policy matter, which, I mean, there's really no way that the citizens could act in this arena through the initiative process effectively.
Well, I don't think that's quite right.
Well, but let me ask you this. I think it's implicit in your argument. If someone decides that they want, say their primary purpose is to have the commercial sale of marijuana for personal use. That's their purpose. Group of citizens want to do that. They're people that sell it, okay? And they want to do that. Is there any way they could accomplish that effectively, in your view?
I think that if you are talking about an amendment that would combine the decriminalization or legalization,
so they could.
Right.
They could just say you can. The people could authorize a commercial sale of a product that it would be illegal to possess.
Right. They are distinct ideas that are not connected by direct inference, that voters feel very differently about, and that are bounded by different policy and analytical considerations.
It seems like this is turning the single subject requirement not into anything other than a straitjacket on the people. And we may think that the people might well think that the people, if they adopted this, would be making an unwise choice. But that's a different question than whether the Constitution basically precludes them from acting effectively in this arena.
Well, I don't think, one, I think what we're asking you to do is consistent with cases that you've already decided. I mean, I think this case is close to the cases that I've talked about. So I don't think it's a departure on what you've said on single subject in other contexts. Also, I think it's entirely consistent with the constitutional reservation of power to the people to propose amendments by initiative, right? I mean, that power has never been a broad, unlimited power. Before 1972, it was more limited, right? You could only amend one section of the Constitution. So the single subject rule represented a broadening. But placed in that historical context, it's not like the citizens of Florida have always had this expansive power to propose any amendment to the Constitution on however many subjects containing however many provisions that they want.
I'm sorry, Counselor, you can have 30 seconds to wrap up.
Yeah, the one thing, the 2 quick points I don't want to lose. One is the point that recreational marijuana is different from medical marijuana. It is different in the sense that decriminalizing marijuana for medical use necessarily implies a distribution chain, right? In other words, a prescription for antibiotics doesn't do you any good for your sinus infection without a means of getting the antibiotics. I think the same is true of medical marijuana. That concern is not present here. A decriminalization can be effective on its own without doing anything else. Secondly, I just didn't want to lose sight of the argument that we make in the brief that the second option you have here is to adopt an interpretation of one subject and matter directly connected therewith. That is more just to abandon the kind of oneness of purpose precedent and say one subject really means one subject and matter directly connected therewith is stuff that's necessary to make it work.
Thank you very much.
Mr. Chief Justice, and may it please the Court, John Bash for the sponsor. I'd like to start, if I could, with what the government has made its lead argument at the podium, which is the other licensed entities issue. And let me just make 3 responsive points to that. The first is that this Court has repeatedly said, for example, in the competitive energy case from 2020, that summary language that just tracks the language of the actual amendment typically is not misleading. In this case, the language referring to MMTCs and other state licensed entities tracks the language of the operative provisions of the amendment, subsections A4 and A5. The second point I would make is that if we had excluded other licensed entities from the summary, there is no doubt that the government would be at the podium saying that was misleading because you have essentially conveyed to voters that only entities with a medical affiliation.
But their argument is really that it allows other licensed entities. So what is your response to the argument that it's misleading because it creates in the mind of the voter that there will be other state licensed entities that are permitted to sell marijuana for non-medical use, when it in fact does not do that? There's an intervening step that requires legislative action.
Justice Sasso, the answer is that the phrase other licensed itself suggests a further process that is not revealed in the summary. Everybody knows whether you get driver's licenses or occupational licenses or business licenses or land use licenses that agencies create requirements, that it's not certain that any given applicant will get a license, and so a reasonable voter reading that would think there could be some process for getting a license. It's possible that there will be other entities that get licenses, but that's simply not discussed. The details of that licensing scheme are not discussed in the 75 words.
Doesn't it at least suggest an existing structure for the licensing scheme?
I don't think so, Your Honor. I think what it suggests is that the state could license other entities, and it avoids the conclusion in the mind of the voter that if they vote for this, it will only be MMTCs selling these products, that it could be other entities if they're able to acquire a license from the state. Another point I would emphasize is that under this court's precedents, the main purpose of this summary is to disclose the chief purpose and then, of course, not to be affirmatively misleading. The process in which non-MMTCs may acquire licenses is pretty far from the chief purpose of this amendment, which is to ensure that adults 21 years or over can personally use and possess marijuana products. It's important, but it's attendant. It's a part of the amendment that facilitates the main right, but it's not the chief purpose. And if we had used language to try to explain that, well, the legislature's empowered, the amendment's trying to not allow for the negative inference that the legislature is not empowered, but there's no guarantee that the legislature will act, we'd use up so many words that the government would be arguing we didn't disclose other things in the summary. There's only 75 words to work for.
Isn't this kind of the point, though, that the chamber makes? Is, you know, you're saying, well, I can't pour the ocean into a thimble, and the answer is, well, then go do this across the street. Go and leave this kind of matter to the legislature. Isn't that the argument that sort of has the most punch against what you're saying?
Justice Coriel, that is the argument the Chamber's making, but it's incorrect. The Constitution establishes one requirement for ballot initiatives, which is that it have a single subject or matters directly connected therewith. I may be butchering the language, but that's a paraphrase. It doesn't tell voters that if you satisfy that requirement, well, some things you'd like to have a vote on that the legislature is refusing to put up for a vote, you can't do. That's the requirement. And the statutory requirements have to give way to the constitutional requirement, which is that voters, so long as they comply with single subject, are allowed to put things up for a vote. And if the statute was interpreted to mean even if you comply with a single subject, there are certain matters you simply cannot put up for a vote, I think that would be in considerable tension with the constitutional right of voters in this context, which, as this court has said many times, is sacrosanct. It's important. It's an important part of the state's democracy that voters be able to put that up. I'm happy to talk about why we believe this easily satisfies the single subject requirement.
Well, what is your response to the argument that we should view single subject kind of as this necessary predicate natural consequence, and if it falls outside that, then it doesn't meet the single subject requirement?
Well, we would urge the court to adhere to the tests it's adopted, but even on the formulation, Justice Sasso, that you just proposed, I don't think that this would fail that formulation. Essentially, this is saying if you have a right to use a product or to possess a product, there has to be the right to purchase that product lawfully with the attendant regulation to make sure it's safe. An analogy that comes to mind is it would be strange if the Second Amendment to the U.S. Constitution were interpreted to create a personal right to own a firearm, but Congress could ban the purchase of any firearm. It doesn't make sense that the ability to lawfully obtain it is naturally attendant to the ability to possess it. And that's all of this amendment does. And as Justice Kennedy was saying, if you kind of reverse it and say, well, what if the chief purpose was the right to sell it? Could you then say nobody has the right to possess it? Well, it wouldn't make sense, because as soon as you did the sale, it would be illegal. I think there are two sides of the same coin, which is a phrase this court has used in describing the single subject requirement. So I don't see how it could violate single subject to say if you can possess, you can purchase. And I think that would be in considerable tension with many of this court's precedents. Not only...
Well, but it's more than just you can purchase. It's where you can purchase and when certain entities may be licensed with the ability to sell. It's much more than the natural consequence of the ability to purchase.
Justice Sasso, for the most part, it leaves those determinations to legislative judgment. It does say you can purchase from MMTCs in accordance with the structure set up by the prior amendments. But in terms of where you can purchase, the amendment does not speak to geographic placement of stores. In terms of what other sorts of entities you can purchase from, that's left to legislative judgment, which, of course, if we had not done that, the Chamber would be arguing that we substantially altered the function of state government by forcing the legislature to do something. So a lot of their arguments have that heads I win, tails you lose aspect. We did a conscientious job of trying to follow this court's precedents. I think that's most clear in the federal law issue, where we followed the roadmap that this court laid out 2 years ago in terms of language. But likewise on the single subject requirement, we did our best to make sure we were not forcing the legislature to act, but at the same time, we were making sure the legislature had the flexibility to inject more competition if it chose to do so as a policy matter. We tried very hard to adhere to what this court's cases have said.
Well, it's also, I mean, the text says directly connected therewith. It doesn't say necessarily connected or logically, inferentially connected therewith. I mean, it's hard to see how this isn't direct, allowing the possession and then setting up a scheme for how it's actually going to be obtained by people. I don't see how that's not directly connected there.
I of course agree with that, Mr. Chief Justice, and the only other point I would add is that we say in the brief 23, but as of last night with the Ohio vote, 24 states have now legalized as a matter of state law recreational marijuana, and in virtually all of those jurisdictions, lawful commercial sale with regulation goes hand in hand with possession. I believe that D.C. is different because of some interaction with the federal control over D.C. And what's arisen there, and I'm speaking far outside the record, of course, because there is no record in a case like this, but my understanding is that there's a very strange gifting economy in D.C. because you can't lawfully sell and people do de facto sales tying to other products. I don't think any responsible legislature in this state or the people would think that in order to amend the Constitution in this way, you have to set up a very strange bartering or gifting system so that people can possess marijuana. I would turn now, with the court's leave, to the federal law issue because my friend raised that in his presentation at the podium. As I mentioned earlier, we followed the roadmap this court set. Justice Kennedy, your dissent in the first medical marijuana case came up at, in my friend's argument. It wasn't just that you said authorize was not proper. It's that you said specifically immunize, what would have been proper, because it tracked the language of the amendment as it does here. And then 1 year later, the court unanimously approved immunize and said this is clearer than authorize, which I took as a nod to your dissent in the prior case. Then in 2021, in the non-medical marijuana 1 case, the ballot sponsor did not mention federal law. And this court said this would have been easy. All you had to do was follow the roadmap from the prior cases, and it would have been fine. The court didn't say that language from the prior cases just barely passes muster, we'll let it go. It said that was the roadmap. 2 years later, we're here with virtually the same language. The minor differences to me are inconsequential, and the government didn't even act like they were consequential until the reply brief. And we followed the roadmap the court set, and putting aside stare decisis, putting aside any other consideration, how could it be that language 7 members of this court unanimously said was a roadmap 2 years ago is now so unclear as to be affirmatively misleading? And that's the crux of the government's argument.
Why the word allow, though, when that clearly doesn't paint the whole picture?
Justice Sasso, 1, that was part of the roadmap language this court told us to use. 2, allow in isolation, I agree, would not paint the whole picture. But then you get into applies to Florida law, does not change or immunize violations of federal law. And in that context, reading the word allows is limited to Florida law because it says so explicitly. Now, one of the examples the government gives in...
it doesn't say it explicitly, though. There's even a sentence in between, or at least a clause in between the explanation that it only affects Florida law and that it allows the personal use of marijuana. So how are we supposed to expect a reader to see the word allow and then know that that word is actually inaccurate because later down in the summary it explains it's only Florida law?
Let me give 2 responses to that. The first is that we expect voters to be able to read things in context. And when a 74-word summary says, 50 words after the allows, that applies to Florida law, does not change or immunize violations of federal law, this court assumes we assume the reader will go back and say, actually, it doesn't really allow because now I've just read this, so I know that word allow doesn't mean what it says. Well, maybe I should get to my second point. I don't think it's true that allows in context always means allows relative to any other entity that may enact a prohibition. I know the parties have dueling hypotheticals about schools in the briefs. Let me just give you another hypothetical that maybe makes it even more clear. Suppose one of the state's universities said, we will allow students to have alcohol in their dorm rooms. So we don't have a rule against that. I don't think any student would reasonably interpret that to mean that if a state police officer came in and saw 19-year-olds with alcohol, that would mean that the state police officer could not give an alcohol citation because the university told them that this allows, they allow alcohol in dorm rooms. And the reason is that, much like the federal and state governments in this hypothetical, those are essentially separate sovereigns. They have their own rules, and no one thinks that the university's rules apply to the state government. Now, even if that was unclear here, even if some voter thinks,
How does that hypothetical help, though? Because there you're dealing with an entity that is not allowed to make laws, and here we're dealing with a constitutional amendment that's going to the voters. They're relying on the summary to help inform what the Constitution is going to permit. I think most voters would say the Constitution, it is the law. It's what's above us all, and it says it allows me to do this.
well, even if that was a belief that some voters may have, that's why, unlike in my hypothetical, we also have the clarifying language in the summary. And this court has said repeatedly, you read the whole summary and the title in context. And there's a reason it's so short. Voters are able to read a 75-word statement and take into account the whole context. It's not long. And just one other example I would give you is this court entrusts ordinary citizens as jurors every day in the state to read complex instructions in white-collar cases, in death penalty cases where it's literally life or death, and because they're conscientious, because they understand the solemnity of their duty, to read something complex, understand it, and apply it. I think the assumption behind the Constitution and this court's cases and common sense is that voters going into the voting booth, knowing they're voting on changing the organic law of this state, will take that duty responsibly and seriously and really think about what they're reading and if this is what they want. And in our view, when it says applies to Florida law, does not change or immunize violations of federal law, the typical voter, most voters, will understand that the federal proscription on marijuana is not at issue here. This is about Florida law, not the federal prescription. And we think that's consistent with what this court said in the roadmap. And again, I come back to the point that how could language that this court said was clear 2 years ago, and not only clear but the roadmap, suddenly be so flawed as to be affirmatively misleading? Even putting aside stare decisis just on the merits, 7 members of this court thought it was sufficiently clear that it should be the blueprint for sponsors. And we tried our best to follow exactly what the court said here. I'm happy to turn to some of the other issues with my remaining time, but I want to make sure I don't foreclose questions from the bench on any of those other issues. So the government makes 2 other arguments, and I'll address them briefly unless the court has questions. One, the government claims that the proposed amendment would actually limit the legislature from repealing pre-existing limits on marijuana that are not covered by the immunity. In other words, that the legislature now couldn't legalize 4.0 ounces or 5.0 ounces. We think that's, 1, wrong on what the amendment does, but 2, if there's some ambiguity on that point, there's nothing misleading in the summary. It just doesn't address that question of future consequences of the amendment. And so I'll just take that first argument briefly. If you look at subsection B of both the pre-existing amendment, and this is on the government's brief at page 4, if anyone is looking there, this is pre-existing subsection B, which introduces the definitional provisions. It starts with 4 purposes of this section. So even putting aside the parties' kind of semantic dispute about whether something's definitional or operational, everything that follows is for purposes of this section, meaning section 29 of Article 10 as amended by this amendment. All that means is that the immunity created by subsections A4 and A5 that would be added by this amendment only extends to 3.0 ounces. It does not bar the legislature independently from changing pre-existing laws. And there's a lot of reasons for that, but maybe the most obvious is the amendment does not prescribe penalties for over 3.0 ounces. So it's unclear what it would mean that it prohibits the legislature from legalizing more than 3.0 ounces as a matter of Florida law. I mean, there's no penalty regime here. The most natural reading of this is that it limits the immunity conferred by the amendment to 3.0 ounces or 5 ounces of concentrate, but it doesn't affect the legislature's pre-existing authority. Unless there are other questions on this, we think that's the clear way to read the amendment. And frankly, the summary just doesn't say anything one way or the other about whether the legislature could raise the limits in the future. In fact, the summary doesn't even give you the amount. It just says there are possession limits. So it's hard to believe there'd be a voter just reading the summary who thinks, well, I like 3, but I don't necessarily want the legislature to go 4. I mean, it doesn't even say the number. It just says there are limits. The last point that the government raises relates to the Department of Health's authority and whether there's this regulatory gap that will be created on day 1 of the amendment. There is no regulatory gap. On day 1, DOH will retain full authority to regulate MMTCs with respect to safety, labeling, adulteration, pesticides, and so forth on day 1. No other, as we've discussed, entities will be licensed on day 1, but the legislature will have full authority to enact an appropriate licensing regime going forward. The government's argument really hinges on the purpose sentence in subsection D of the proposed amendment, which is at page 7 of the government's brief. And the government says, well, if the purpose of the DOH's regulation must be to protect qualifying patients, then once recreational marijuana is allowed, do the regulations have any purpose? The answer is yes. That sentence fits seamlessly with the regulatory scheme that would be established by the amendment. And the reason is that what the amendment would do is say you can purchase even if you don't present your qualifying patient card. But it will still be true that numerous qualifying patients, people that today satisfy the statutory definition or the amendment definition, will be going to MMTCs to purchase products. And they will look at all the products on that shelf, and when the Department of Health says MMTCs, no matter what you sell, no matter what you produce, you need to continue to follow the safety standards, that is protecting qualifying patients.
But isn't there argument more fundamental at the end of this, during the period of their what they suggest is a regulatory gap? These aren't patients anymore. The whole logic of lodging this in the Department of Health in the first place is the idea that it was medical marijuana and that folks who were buying it were seeking it as a vector of treatment. This changes that. The buyer is no longer a patient in any meaningful sense. So from a regulatory standpoint, it may or may not make any logical sense to house it even in the Department of Health. Legislature may decide this doesn't belong in the Department of Health. I guess that is the sort of structural gap that they've identified. How do you respond to that?
So if that's their argument, Justice Coriel, that's not cognizable in a 101.161 challenge. This court has said repeatedly in the voter control of gambling case, in the Department of State versus Hollander case, that ambiguities or even flaws in the amendment, stuff that doesn't make sense under some points of view in the amendment, is not what the court's analyzing in a 101.161 challenge. And there is simply nothing in the summary, which is the focus of the analysis, that relates to this purported ambiguity or arguable flaw in some people's view, not ours of course, but in some people's view, flaw in the regulatory scheme. Why is DOH the entity regulating sales that are not exclusively to qualifying patients? That's a policy argument that the Attorney General can make on the stump if she opposes this amendment and say, well, this doesn't make sense. Why would DOH be regulating this? But that does not relate to anything that is affirmatively misleading in the summary, and it certainly is not the chief purpose that must be disclosed in the summary. It's essentially a question of statutory interpretation or purpose that's not the subject of a 101.161 challenge. I see my time's expired.
You can
Mr.
have
Chief
30
Justice.
seconds to finish up.
This court has said many times that it's reluctant to strike language from the ballot. There's strike a ballot initiative because it's a solemn responsibility of citizens and a solemn right to amend their constitution. If there was ever a case not to do it, it's the one where the ballot sponsor looked at this court's precedents, tried to follow them scrupulously, and even adopted the language that this court said is the roadmap. Regardless of standards of review or stare decisis, this is not a case where the language is misleading or that violates the single subject requirement. Thank you, Mr. Chief Justice.
Thank you.
I'd like to try to make 2 points about our other state license entities argument. So Mr. Bash has responded that, well, the sponsor was just drafting the summary to track the actual language of the proposed amendment. But we don't think that that's true. What the proposed amendment says on this score is that, and this is in proposed subsection E, the legislature may provide for the licensure of entities that are not MMTCs. So the amendment leaves it to the legislature, and what the ballot summary says is that the amendment meaning the amendment itself, would allow other state licensed entities to engage in this conduct. Now, voters may understand that in any number of ways. They may think that there are existing entities like pharmacies that now will be permitted to enter the marijuana space. They may think that the amendment itself creates a licensing regime, which is totally plausible, or they may think that the amendment requires the legislature to adopt that licensing scheme. But what they would not think...
If it's possible that the language was necessary to avoid the negative implication argument about mentioning the MMTCs but no one else, I mean, there is a sense in which the amendment does allow it. You know, and I'm not, I mean, obviously people in subsequent cases would be arguing about whether this added any value or not, but if you start from the premise that it did add value, then there is a sense in which the amendment is having the effect of allowing those entities to do it, assuming that the legislature chose to actually create the licensing regime in the first place.
Well, I think, Your Honor, the only sense in which the use of the word allows is accurate is in the sense that the amendment doesn't affirmatively block other state licensed entities. It just leaves it to legislative discretion. I mean, it's a little bit like saying, you know, in a totally different constitutional amendment dealing with search and seizure protections that, well, the amendment allows other state licensed entities to engage in the marijuana trade. Like, of course that's true, I suppose, but it's not the ordinary way that we think about a term like allows. And I think the more reasonable way for voters to understand this is that after ratification, entities will be able to apply for a license and go through an administrative licensing regime, not that they will have to go to the legislature to lobby for the creation of that licensing regime. Thank you.
Thank you very much. We're going to take a 2-minute break and we'll be back. Thank you. Oh, I'm sorry. No. You can just briefly, yeah. I think you used up all your time, but if you go ahead.
I just want to try
1 minute.
I just want to try to take a quick shot at your question, Justice Muniz, about the direct connection piece of the single subject argument. Page 5 of our reply brief, we talk about the word direct and how it is kind of without intervention, immediate, and that's kind of the idea that I'm trying to get at when I talk about is it a direct inference or a logical inference. I think on that subject, right, the sponsor wants to kind of position this as a right, and I realize we use some of that framing in our brief as well, but really, strictly stated, it's not a right. It's a protection from criminal prosecution or civil enforcement. If this was a right, you might say there was a direct connection between the commercialization and decriminalization aspects of this, because...
But I'm sorry to interrupt you, but doesn't Justice Kennedy's flipping it, if the main purpose of this is the commercial part, then clearly you would agree that from that perspective, the decriminalization is essential. It's inevitable, right?
Well, I mean, maybe it's a closer call, but I do think, you know, the commercialization contemplates a lot of things besides just sale. It contemplates cultivation, distribution, and of course you have.
But then it really doesn't. Then what you're comparing isn't commercial versus decriminalization. You're saying within commercial is, you know, should you be carving that up, that we want you to be able to sell but not grow, you know, something like that.
But even putting that to the side, they are discrete subjects under this court's precedence. As a matter of logic, they're distinct. They're bounded by different considerations, and voters clearly could perceive them differently.
But isn't it the case that under our precedence, the level of generality at which we've analyzed this has gyrated wildly, and it has depended on who knows what?
Yeah, and that's why I started.
I mean, it's all about the level of generality when you're looking at single subject analysis, right?
I do think that one thing that pervades your cases is kind of like, what's the right level of specificity or abstraction? I agree with you on that. I'm not sure how important that is here, because I don't think there's all that much water between the parties about what this amendment does, right? There is a piece of it that is directly related to the personal use, and there's a piece of it that deals with commercial sale. I know I'm
go ahead.
running short on patience, but I did just want to try to address your question, Justice Kennedy, which was, you know, I think while we don't think you could put both of these topics on a single amendment, I do think you can honor the citizens' power to amend their constitution by initiative by requiring them to be put as separate items, right? That does two things. It honors the citizens' constitutional entitlement to vote by initiative, and it simultaneously honors their right not to be put to an all or nothing vote on things they may feel very differently about. Here, whether they want decriminalize marijuana, and on the other hand, whether they want a large commercial apparatus that makes it widely available.
So we would have to, though, recede. I mean, we have precedents basically saying that if it's part of kind of a coherent plan, that it satisfies single subject. Wouldn't we have to recede from that? I mean, it clearly meets that test, right?
Well, and again, I'm not sure that there are precedents that you would have to recede from. Like, I think that probably the right exercise here is to look at what are the most analogous precedents to this situation, and what do those, like, what can you tease out of those cases? And when I look at the most analogous precedents, and I think they are nonpartisan commission, fine, and Save Our Everglades, what you have is a series of conceptually related ideas that aren't directly connected in an inferential chain. And, you know, as I say, I think that this is very different from the medical marijuana cases because of the direct connection between the medical purpose of the use and the need for a commercial distribution chain.
Okay, thank you. We really appreciate the excellent argument and briefing, and we'll be back in 2 minutes.
All rise. Supreme Court is again in session. Please be seated.
Hi, we will now take up our second case, statewide guardian ad litem office versus CC and others. Case number 23-0604, and Justice Sasso is recused from this case.
Mr. Chief Justice, and may it please the court, my name is Stephanie Zimmerman, and I represent the Department of Children and Families. The Department of Children and Families respectfully requests that this court reverse the decision below and reinstate the termination of parental rights judgment because the plain language of Chapter 39, this court's precedent, and the decisions of 5 different district courts of appeal have held that where there are extraordinary circumstances, such as this case, that termination without a case plan is the least restrictive means of protecting the child. There's 3 key facts that we ask that this court keep in mind as we navigate the issues today. That first fact is that the father admittedly has never had custody to his soon-to-be 6-year-old child. The second fact that we ask you to keep in mind is that the father has never exercised parental rights or responsibilities because, in his own words, at most, he has had a 4-hour supervised visitation with the child, once when the child was 2 and once when the child was 3.
Do you argue that that constitutes abandonment?
We do argue that it constitutes abandonment, but the actual finding of abandonment was never challenged in the trial or in the appellate court below. That ground actually remains undisturbed, and that's what we've asked you to keep in mind as our third point, that the 2 grounds for termination of abandonment and continuing involvement under 39-806(1)(b) and (c) were not disturbed in the 5th DCA's decision. And because of that, the plain language of Chapter 39 states that reasonable efforts aren't required.
Well, don't you think there's 2 different things? We have the statute that the legislature has said, you know, before you terminate parental rights, here are the things for reunification for that. Here's some cases where you don't have to do that. You can go straight to this. That's the statutory scheme. But that's not where the least restrictive means prong comes from. That's a judicially created element. For better or worse, that's what we have. And so can you point me in CC, the case that we have today, not based on the facts. I understand you disagree with the application and the way they came to the decision, but point me to where the opinion holds something different than what the other opinions have held. Because essentially what this opinion says is there are no extraordinary circumstances here. It doesn't say you need more. It doesn't say you need less. It says there just aren't any. And the cases are distinguishable. I mean, this father did not abuse. I mean, there are some distinguishing factors here from your other cases. So where is the holding in CC that is conflicting with this sort of holding in SM or these other cases?
The holding in CC that conflicts is where the court starts to recognize this prior precedent in the RW case from 2017, now the 5th DCA, recognizes it, but then does not apply it. That RW case specifically speaks to this court's own precedent in re the interest of TM. It also speaks to the application of 39-806-2. So let me talk about in re the interest of TM first, this court's own 1994 case. That was the case in which this court first came up with the concept that in the prong of least restrictive means, which is judicially created, that there are some cases where there are extraordinary circumstances. The particular extraordinary circumstance in that case was pursuant to the ground that was 39.4643. That ground is the continuing involvement of ground that has evolved into 39-806-1C that is in this case. And that's what RW recognized. And that's actually what CC actually said too. We've had this evolution of numbering, but not what the grounds actually are. And because of that, because this was an extraordinary circumstances case that this court has already recognized, then application of 38-806-2 is constitutional. Because what our legislature has done is it says, now there can be very different facts that lead to all kinds of things that would result in termination of a parent's rights. But these categories of cases, these are our extraordinary circumstances cases. And so there's been a lot said in the briefing about what specifically this man has done to this child. This child, for 6 years, as of this point soon, has had that uncertainty in his life. Every opportunity that this man was afforded ended with either an arrest or a sentence. And it's that uncertainty that really this court focused on in the SM case. In SM, we have to talk about the least restrictive means test and the concept of the right that's involved. The right that's involved is the right to be a parent to one's child. Now, when you're a parent to the child, this court explained, it's all the rights and responsibilities that that entails. He's never had any rights and responsibilities to this child because he would always engage in some kind of behavior that would absent himself from the child's life. And so when we look at SM, and SM standing for the proposition that we have to look at, can that child be reunified? And if that child can't be reunified, which this child could never be reunified with this man throughout the entire duration of this case, then that judicially created least restrictive means test has been satisfied. And that's, yes.
So I think that what's interesting when you read all these cases is that you have all these different, very thoughtful judges describing the least restrictive means test differently. Yeah. And obviously one thing that we could do with how we resolve this case is either fix a mistake or say that it wasn't a mistake. But then in terms of going forward and providing guidance to the courts, it seems like, if possible, we should use this opportunity to kind of clarify what the least restrictive means thing is and how it fits into the statutory scheme. It seems like the most recent attempt by this court at explaining it was in SM. Yeah. And if you read SM, it does seem like it doesn't seem to accept the notion that as long as one of the factors in one of the grounds for termination other than sub E is established, that that's per se least restrictive means. I mean, do you agree with that?
Not necessarily, Your Honor, and the reason I don't exactly agree with that is because 806-2 was not the issue that was raised in SM. In SM, the parent never, in the briefing of that case, addressed the application of the particular ground. Grounds were admitted in SM. Instead, what they tried to do is explain that the least restrictive means test should take into account all least restrictive alternatives. And one of those alternatives can be permanent guardianship. And what this court really painstakingly did was look through the permanency options that are available under Chapter 39, the right that's involved when we talk about least restrictive means, and then find that ultimately any kind of bond that that parent was trying to retain in that case could not be at the cost of the child's future. So I can't agree that this court necessarily dismissed 39-806-2 and the difference between E and all these other grounds, because that really wasn't the issue. If we accept your position on 806-2, where does that leave the least restrictive means test? Does it still do any work, or would we be better off in the future? Which I know some, Justice Quintero and I guess Sawaya, they believe that the statute has evolved to a point where it's sufficiently comprehensive that if you just follow the statute and treat it as a two-pronged test rather than a three-pronged test, you're complying with whatever the Constitution might require. Do you agree with that? I do agree that definitely there's been a lot of change since the first Padgett case in 1990, because at that point in time, this court had to develop the least restrictive means because the actual body of case law as well as Chapter 39 itself were not well developed. At that point in time, there were 3 grounds for termination. One of them was through the traditional case plan path, and the other 2 were the continuing involvement ground and the extraordinary egregious abuse. But we've evolved as a state, and there's so many other things that have happened now. Now we have multiple grounds for TPR. So I do think that this court should take the opportunity to clarify the least restrictive means test, because I absolutely agree that from Padgett to NRATM to Florida Department of Children and Families versus FL to SM, every one of them is kind of using a different least restrictive means test, but it's always been because of the particular issue before the court. The one thing that I struggle with the position that you guys are taking on 806-2 is if the least restrictive means test is truly a constitutional requirement, then the mere fact that if the legislature says if any of these 8 things are found, then you don't need to
attempt reunification. It seems like maybe if you're just reading the statute, the legislature could say that, but I don't think that the legislature can just declare that due process is satisfied by doing X, Y, or Z. We would still kind of have an independent obligation to see if that's true. And so when you guys cite this stuff about, reading the language of the statute and all that, like, that's fine because it tells me how to read if I draw a circle around the statutory scheme, that's true, but it doesn't answer the question whether in a particular case someone's due process rights were satisfied. Does that make sense?
It does make sense, and I absolutely agree with you. The legislature cannot just say that due process is met because this one event occurred, but it's the process that is proven in that particular case. The one takeaway that we have from Florida Department of Children's versus FL is that we have to look at the totality of the circumstances and how we got there. So in proving that particular ground, we have to look at the ultimate harm that's involved. And so in this case, the particular grounds are there is a true harm of being abandoned for nearly 6 years at this point in time. There's a true harm actually in the plain language of the particular ground 39806.1c, where it says that this is contrary to the child's health, safety, well-being. So if there were to be just some legislative ground that comes up with any parent that doesn't have their child be a vegan, now that's going to be, we still have due process requirements that we have to abide by, and the department's not asserting that we don't have to comply with due process. In this case, there was due process. There was multiple attempts to engage with this father, to provide him services, and unfortunately, due to his actions, not once, not twice, not 3 times, but 4 and more times, he got arrested. And despite the provision of due process, we stand here today where his rights need to be terminated so that this child has the opportunity to be raised by the person who has been raising that child for the last 5 years.
Okay, we'll hear from your colleague, and you can retain your 1 minute of rebuttal.
Thank you.
Chief Justice, Your Honors, good morning. Sarah Goldfarb on behalf of the statewide guardian ad litem office for the minor LA. I'm going to start with the question that Chief Justice Muniz was just asking the department related to the legislature can't just declare when due process is satisfied. And that's true, but I think the key point here is the legislature didn't just declare due process satisfied. It codified TM. It codified a prior holding of this court in which the constitutionality of the ability to terminate parental rights without requiring proof of reasonable efforts or a case plan, it found that constitutional. That was the issue in that case. And so to the extent the legislature has extended the grounds for which case plan requirements aren't required, it has done so from the direction of this court, that can be done, and that each of the behaviors or each of the grounds it has chosen to include have been specifically tied to the conduct that's in those grounds. That's why the case plan grounds, the E grounds, they're accepted, because they're not based on behavior that is inherently or fundamentally at odds with assuming parental responsibilities. What the behavior in the grounds that are included in 39.806, those sorts of behaviors are specifically tied to parental conduct that is antithetical to the assumption of parental responsibilities. Abandonment is defined as harm to a child. As the department said, subsection C includes a finding of a risk of harm to the child. When we get down to F, the egregious grounds, I think that's the easiest case. Those are the most heinous acts that we see our parents coming into court with. And as you go down the list, they're specific acts of harm to a child. That's what brings the case in, or that's what the grounds for termination are.
Is it fair to say, Judge Altenburg had that one opinion where he was kind of trying to explore the idea that there was kind of a substantive component to this and a procedural component to it from a due process perspective, and that the substantive aspect is what are the reasons that the legislature says are things that can trigger the termination of your parental rights, and those things have to meet some kind of substantive test that's tied to whether you're harming your child. And then depending on which thing it is that has caused you to kind of forfeit your rights, you may need a different sort of procedural path to have that be established. And so if the thing that caused you to forfeit your relationship with your child is that you essentially just can't, get your act together as a parent, and you've had all these opportunities and you've, failed a case plan and whatever, that sort of builds in this kind of least restrictive concept. But if the thing that caused you to forfeit your rights was abandonment or, extreme physical abuse or something like that, that essentially there is no corresponding sort of procedural right that you have, other than just the rights that go with, having it be established by clear and convincing evidence. I mean, is that a sensible way to look at it? Because the least restrictive means thing, I think it would be a shame if, and it may be that it's not fixable, but I do think that our court, I think you could help us think if there's a way going forward to kind of more precisely tell the lower courts what it is that they're supposed to be doing with that.
I think that's exactly it. The termination scheme is a whole. There are three parts to it. There are grounds, there are manifest best interests, and then we have the judicially imposed least restrictive means. And one of the difficulties, I think, with the CC opinion is that it really looks at least restrictive means in the vacuum. And it says, well, this feels unfair for these reasons, without backing up to look at, well, first we had to get to grounds, and those haven't been challenged here. Those have been conceded essentially as being correct because they weren't raised. So we have abandonment, and we have what we call the continuing involvement ground. That's harm to this child. And I think where the opinion kind of makes a second misstep is then it reconsiders harm to the child under the least restrictive means test. And those pieces, the due process piece and the risk of harm piece, have been talked about in tandem in quite a few cases from this court, because in many of those cases, the issue is not so much whether there was harm, but the harm was not to the child to whom the parents' rights are being terminated. And so we have this nexus issue that complicates the matter. And so when we're talking about fundamental fairness, what's fair for terminating parental rights to a child who the parent truly hasn't harmed because it was a later born child or whatever that might be? That's where things become more complicated when you're looking at least restrictive means, and is this fair? When, as in this case, you have the child at issue is the child who has been harmed. This is the child who was abandoned. This is the child for whom continuing the parent-child relationship is harmful. Those behaviors are sufficient to terminate parental rights under this weighing of fundamental fairness under due process, because this is a child protection proceeding. This is about the child. This is about this. The legislature, this court, have clearly stated that the primary goal here, the primary consideration, is the child's welfare. And that is the principle under which everything else falls. As this court has said in its precedent, that is where fundamental parental rights yield. They yield to the best interest, to the welfare of the child, because that's why we're here. And so due process to a parent, fundamental fairness, it's not a ceiling, it's a floor. And we want things to be fair, but the goal of this is to achieve safety and stability for the child, and we can never lose sight of that. And I think that's where the Fifth District's opinion, I think, went a little bit off course. I do think it also didn't start in the right place. The opinion begins with, it acknowledges that case plans are not always required, and it says, but in any event, we have to prove least restrictive means. And from there, it moves to reasonable efforts without ever taking that step to consider whether 39.806 subsection 2 directly applies, and to consider whether or not a case plan was required in the first instance. And I think had the court started at that point in time, the court would have been able to put 39.8062 NTM and the case law that concerns the lack of a need for a case plan in context. It would have kept them on track going through the rest of their analysis.
Why, so this 806 1C, where it talks about harm kind of irrespective of services.
Yes.
Why is that not, and I'm not an expert in this stuff, so there may be an obvious answer to this, but why is that not similar to E in the sense of those, it seems like C and E are similar in that they do kind of on their face textually kind of focus your attention in part on what the department was or wasn't doing before the termination petition was filed, which SM tells us that that's kind of supposed to be the focus of least restrictive means.
The difference is, I think, fundamentally that the subsection C ground it doesn't require a case plan. So you can terminate parental rights under subsection C because services are futile. And that might be in a case where you have a parent with a mental illness and, maybe they've been receiving treatment for many years outside of the dependency system. And when they come in, we know that we can prove that there's nothing that's going to be able to rehabilitate them. In this case.
So the language irrespective of the provision of services does not mean irrespective of the provision of services that have been provided.
Correct.
But it means irrespective of the provision of services that might be provided.
Yes.
Is that what you're saying?
Yes. There's there's a case called PO. I unfortunately can't remember the citation for it at the moment, but that was a case in which the department had not made reasonable efforts, but the parent had access to services in other areas. And so termination in that case was affirmed because that parent could not benefit from services, prolonging the case to require the department to provide reasonable efforts, to provide a case plan, was of no benefit because we already knew that wasn't going to be successful.
Although the statute goes on, though, to say that provision of services may be evidenced by proof that services were provided through a previous plan or offered as a case plan. So it seems, I agree with you that ultimately what you're showing is that there's no point in doing anything more, but it's not just sort of this hypothetical, like this person is so, it seems like it could be a mix of what we maybe could have done and what we also did and what the results were that we got. That's one where it's not as obvious as, some of these things just seem like someone did something egregious and there's nothing, you've sort of forfeited your parental rights at that point and we can move on to what's in the best interest of the child prospectively. Some of this other stuff, and it's not just it seems like there may be some work for the least restrictive means to do. So for example, the one about drugs being found in the child's system. So if you just read 806.2 literally, that would mean that a father who didn't necessarily have any role or control over the drugs being in the baby's system when it's born, would you say that could be a trigger for terminating the father's parental rights and then going straight to the manifest best interest problem?
No, Your Honor. That subsection, I believe, only applies to the mother who's carrying the child. If we're talking about at birth.
It's not written that way, but
I can tell you in my experience, I have never seen it
applied
to a father who has no control over what the mother put in her body during pregnancy.
Okay.
But to go back to your point, I see my time. To go back to your point, there is some overlap, I think, between the C and the E grounds, and there are instances in which they both may apply. What the E grounds look at, though, is the department has made reasonable efforts. The requirement is the department has made reasonable efforts, and that the parent for the E3 ground, which was the one grounded issue here, we're 12 out of 22 months with the child in out-of-home care, and the parent still isn't there. It doesn't mean the parent can't ever get there, but what the E grounds do is they set more of a time limit on it, whereas the C ground focuses more on the remediability of the parent's behavior or conduct or whatever is, the cause of the dependency at issue. And I think that the C ground, because it is irrespective of services, is what makes it a ground that qualifies under 39.8062. This is a behavior that we, by nature and by the elements, have to prove we can't fix. There are not any more services that are going to address this, that are going to change this parent's behavior, whether because the parent can't change or because the parent is choosing not to change. And that's really here. This is the choice of the parent, the choice of the father in this case to continue his decades-long history of criminal behavior and his inability to change that pattern, even though he knew his rights to his child were on the line.
Thank you. You can have 1 minute for rebuttal.
Thank you.
Good morning, Chief Justice. Justices, my name is Keith Peterson. May it please the court. I'm here for the respondent, CC in this case, and here to support the finding in the 5th DCA that reversed the trial court's termination of my client's parental rights. This is a case where his primary problem was he couldn't stay out of jail. Otherwise, he did what he could in terms of...
Well, counsel, isn't that a little bit of a stretch? Because You know, he had the opportunity to move to Florida, and then if I remember correctly, what's in the what I read, and if it's inaccurate, what I read, he didn't like the atmosphere, and so all of this is complicated by his decision to stay. And I understand during some periods he didn't have any choice about being in North Carolina because he was in the custody of their Department of Corrections. True. But even aside from that, he made choices that made it more difficult for him to establish any kind of meaningful relationship with this child. I mean, he begat the child and decamped to North Carolina and then made these kind of occasional efforts. And isn't that part of the picture here too?
It is, Judge. A good share of the dependency system is predicated upon parents who make bad decisions. If we take bad decisions out of it, we don't have a whole lot left. We would argue, however, in this case, the dad, one of his problems was he needed a home study, a positive home study up in North Carolina. North Carolina told him, because your criminal record, we're not going to give you.
You tried to burn down the family home, right? Wasn't that what was going on there?
If that is the case, I'm thinking of it was 10 years prior to the birth.
Well, I understand, but at some point he tried to torch the family home, correct?
But he put himself in a position to be able to have a home study but for his criminal record, and therefore he was not going to be able to achieve any kind of reunification. He made plans then to move to Florida, to relocate to Florida, and to do an updated psychological at the request of the court, and also have a visitation in person with the child.
But then when all this was going on, he then gets arrested, he gets convicted of assault and a felon with a firearm and all that. I mean, it seems like this is a very complicated case when it comes to trying to make sense of least restrictive means and what we would say for guidance going forward, if anything. But I mean, it seems difficult to argue on these facts, especially given that you didn't below contest the abandonment finding, that whatever sort of due process someone has before the state can go ahead and initiate termination, that this person's background, if the goal is, you know, can you be a parent, not. It seems like our case law is clear that the question isn't, you know, can you be a benign, non-harmful presence somewhere in the child's life, you know, doing Zoom calls once a week or whatever, but can you be a parent? It just doesn't, it seems very unreasonable to suggest that this person has not had a fair opportunity to see whether that's possible. And for this poor child, for what, you know, 5 years old or whatever, and has, you know, been in limbo. I mean, could you? That seems implausible.
Well, sure. And one of the complicating factors in this case is that Dad had frequent visitation with the child, both virtually 2 to 4 times a week, and in person 3 to 4 times a year. And all of his interactions with the child were positive. And that distinguishes this situation from a lot of the others where one of the cases I was looking at, Dad had is diagnosed schizophrenic and he wouldn't stay on his meds. That's a difficult situation. The importance being, if the child were to be placed with that father, the kid's not going to be safe. In the situation with CC, there's no indication that the child, if the child were to be with the father, that the child would not be safe.
How can you ask us to buy that based on what we must accept and what you haven't contested below about the findings of the trial court with respect to abandonment?
And I would argue, Judge, that the issues were addressed by the original appellate attorney, who wasn't me, but they were addressed in that he extensively went into the least restrictive means issue. And especially as it pertains to this situation, this is a case, as y'all are aware, was filed under sub B and sub C. And there's also a 1E3. That was the basis for the original termination.
I'm confused. I'm sorry, counsel. So are you arguing that former appellate counsel did make challenges to the trial court's finding on continuing involvement and abandonment?
I'm arguing that least restrictive means was the primary issue, and he argued that issue, and it applied across the board. He might not have organized it and articulated it the way I would have. However, since he extensively argued least restrictive means, he did not waive.
So you're saying that it's not waived?
Yes, exactly. Least restrictive means that issue is not waived. No, ma'am.
Well, you know, let's get beyond the issue of waiver. And maybe I missed it, but I read your brief, and you assert that the grounds of continuing involvement and abandonment were not established. Correct?
Correct.
So I see that assertion, and it seems that your whole argument kind of hinges on those assertions, because that takes you, if that's the case, then that takes you out of subsection 2, correct?
Perhaps. Go on.
Okay. Well, I thought that's what you argued.
I'll articulate. I want to hear your question.
Pardon?
I want to.
We don't know where I'm leading you. Okay. I understand. You're going to find out. But I don't. So I see that you've made this assertion that those grounds were not established, but I have not seen an argument that explains to us why they weren't established.
Okay.
I mean, I just don't see it in the brief. You make the assertion, but then it's not really. And I think the guardian ad litem and the reply brief actually focused on this. I don't really see the argument where I can look at what you say, and I guess in some ways what you're making is a tipsy coachman argument.
To a certain extent.
But I don't think you just assert a tipsy coachman basis without explaining to us, based on the law and the facts, why that would be a correct way to uphold the decision of the district court. And I just don't see it in your brief. And if I'm missing it, you point me to it.
Okay. What I would argue, Your Honor, is that in a typical TPR case, the department has to prove the statutory ground, best interest, and then in some situations, least restrictive means. And the subsections B through D and F through M have basically said the department does not have to show least restrictive means in those cases, and those are typically extreme situations. Some of the statutes specifically go into the horror show that oftentimes is these cases. What happened in this situation, though, is the department chose to file what I think the Fifth felt was not an extraordinary situation under sub B and sub C. And my argument is that the department, by doing that, is attempting to rid themselves of the need to prove least restrictive means through a provision of services, because this is a case where Dad never had a case plan. Dad did not have a case plan. The court ordered one at one point.
But isn't integral to your argument there your assertion that the grounds under B and C were not established?
At trial, and this was
I understand that's where they would be established. Right. If they were going to be established.
Right, and the Fifth said that they did not establish those grounds. But my issue, and perhaps I didn't articulate it well, but my issue was that due to the filing decision to go through sub B and sub C, the department absolves itself of the responsibility to show services or the least restrictive means through the provision of services in a case plan. There was no case plan here, and so since this is not an extraordinary situation, the department is trying to short-circuit the system, and a lot of the due process rights are right there.
So if there's abandonment, there doesn't have to be a case plan, does there?
No.
Okay.
No.
Well, so if abandonment is established, then all that is just kind of a moot point. And the trial court decided that there was abandonment. And you have not shown me, from what I see in your brief, I don't see an argument that the trial court was wrong about there being abandonment. I just don't see it.
I think the DCA made the finding that with the father that had, due to his, or given his circumstances, he still maintained substantial and significant contact with this child. Frequent contact through virtual and in person.
Wait, on the in-person front, isn't the record that it's less than 5 hours total?
My recollection was that there was testimony that he 4 to 5 times a year, or 3 to 4 times a year in person, and 2 to 4 times per week virtual.
Right, but in total, isn't it true? Am I mistaken, or is the record that we're talking about over the life like a grand total of 5 hours in person?
I don't want to say that's not correct, but okay. I don't have a specific recollection to say one way or the other.
So I'm having a hard time understanding your position, though, because it sounds like you actually agree with the other, and I thought your brief could have been read this way too, but I just want to clarify. It sounds like you're kind of agreeing with the premise that if any of the termination factors other than E are proven by clear and convincing evidence, then the least restrictive means test goes away.
I think it has been made fairly clear that in extraordinary circumstances, the department is not obligated.
Do you accept their premise that those things are sort of by definition inherently, that every case that meets any of the circumstances other than E, that it is legal, for legal purposes, extraordinary?
I would accept the premise that the purpose of B through D and F through M are to basically give a landing spot for extraordinary circumstances, and I would argue that by the department filing non-extraordinary situations under statutory provision for...
Okay, so that seems like it really does come down then. It seems like you both agree then with the legal question, and it's just a question of whether B and C were in fact proven by clear and convincing evidence, and it seems like that ship has sailed. I mean, that, you know, you're not telling us now what the error was. No one below was clear about it, so... I mean, it makes me wonder why we're even here. I mean, because it seems like the legal question that we would properly be here to be resolving. It sounds like both sides agree. I mean, and I don't know that I agree with either one of you on that, by the way. I think the DCA made a mistake. If we just if we treat the least restrictive means as a separate prong, and we say that even if you prove, B and C. There is still this sort of constitutional minimum that has to be protected. I still think that the lower court kind of fumbled at that stage. But it sounds like you guys don't even disagree on the legal question.
I would argue, Your Honor, that our concern is that if the department is allowed to file non-extraordinary situations under one of those provisions, B through D and F through M, designed for extraordinary situations, then they basically just absolve themselves of responsibility.
If they fall under
services.
But counsel, you'd have to admit that if your option is if they file under the wrong ground and there's not a factual basis for establishing the ground, you have to challenge the ground. I mean, that's just kind of basic.
Yes,
and so if that doesn't happen, if that's not done at the lower level, and then it's like even though somehow the district court stumbles and gets the right result from your perspective, even though you fail to do that, they get the right result, then to come up here and to try to get that sustained on this tipsy coachman, and maybe I'm missing that, but it seems like that's what you're arguing. It's really a tipsy coachman argument. Then you don't really give us any reason to say that the decision is correct for these other reasons, and show why the trial court erred in those regards, and therefore it was correct for the district court to reverse the trial court.
Right. And I can answer that, Judge. Your Honor, the reason that the ruling was correct is because if the department is allowed to proceed without least restrictive means in usual, normal situations, non-extraordinary situations, they don't have to provide services as a means of expressing the least restrictive means. Case plan is how it typically plays out. And if the department is not required to provide those services, that's where a lot of the fundamental rights live, are in that providing services process. The case plan, the parent working on the case plan, succeeding, failing, there's a lot of rights that are housed in that process between shelter and termination. And to eliminate that in non-extraordinary circumstances would be a substantial sort of imbalance in terms of the power of the government to reach into the lives of private citizens without that due process in the middle.
But at a certain level, counsel, who could disagree with your position that the state should not file under a ground that's not warranted by the facts? Okay, that's just kind of axiomatic. But that does not address what happened in this case, where that has not if this failure of the state to have grounds to establish these grounds, it's not been litigated. It's not been litigated in the district court, and it's not really been litigated here. It's been asserted, but not actually argued, unless I'm badly missing something, like pages got stuck together in the brief when I read it. I don't think so.
The problem that the case, to a certain extent, presents is that there was not a future potential threat of the father and the child interacting. That is a feature of an awful lot of the other cases that there's a problem, like the schizophrenia case, obviously, that's going to present a future problem if dad and child were to be reunified. In this situation, there's no evidence that that would be the case, because we have a dad who's, all of his contact with the child has been universally appropriate.
Well, and the last point in this, has the father ever actually said, I'm ready to take custody, I want custody now?
At one point, he wanted a home study in North Carolina, and he couldn't get it, so he made plans to move to Florida. So that was his.
But based on the record of the way things are in this case, when this came to us, was the father in a position to take custody of the child, in your view?
If he was requesting a home study, I assume that he was in a position to do that. If the only reason North Carolina was rejecting the home study was the prior criminal history, there's no indication that there was other basis for rejecting or for the denied home study. He came to Florida because he thought he could get a positive home study, because the metric, I guess, used down here is different than North Carolina for home studies.
But he never, how long, did he, to have a home study in Florida, you got to have a home in Florida, right?
And that's what he was working on, and he picked up his last arrest. Yeah, he was in the process of making that move. He picked up the arrest. He ended up doing state time, and I think his sentence was set to end a couple of months ago. But yeah, he was making that move, but that is when his latest arrest happened. But his crimes, none of his crimes were child-related. None of his crimes involved his kid. That's another complication.
Well, maybe there wasn't a child in the house, but torching a family dwelling seems to me to be a pretty serious thing.
And again,
and waving a gun at people, whoever they may be, seems to have serious implications for the child's welfare.
Right, and we would argue that this is not a world where no new law violations remains a potential condition of the case plan. That was eliminated a long time ago. And as such, just having the incarceration problem isn't the same thing as some of these other issues that are not subject to remediation, the schizophrenia, the unresolved drug issue, things like that. Right? So it's a different critter. It doesn't, I'm not saying it gives him a blank check. I'm not saying he gets a pass. However, because it's different than the psychological issues and the drug addiction issues that are not resolved, it does end up playing out in a future tense differently than those other kind of situations. So here, I would argue that the critical necessity of the Fifth ruling in CC is that it creates the necessity to maintain the due process, the least restrictive means as expressed through case plan requirements. In that process, between the shelter and the termination, and by allowing the department to rid themselves of the obligation to provide those services, that filtering process that allows parents to either succeed or fail through a case plan, that's where a lot of the due process rights are. And in this case, there was no case plan, so there was no opportunity for the father to demonstrate that he could potentially parent this child in the future. So, other questions, Your Honor? Thank you for the opportunity.
Thank you.
I'd like to take this opportunity to try to address what I feel is Chief Justice's main concern, which is where do we go from here? And I think we start back to where did least restrictive means come from? And back in 1991, this court said that to protect the rights of the parent and the child, the state has to show by clear and convincing evidence that reunification with the parent poses a substantial risk of significant harm to the child. So let's talk about that risk, and let's focus on that risk as we go through the different grounds. What the court attempted to do back in Padgett was give one example where you can establish risk, which is you work your case plan and you don't benefit from the services because you don't change your behaviors. That is one way to establish a risk. And I think that was all that they were trying to do, was establish an example. But since then, there's been many more examples of how you establish risk. You establish harm by abandoning a child, which is what we have here. And I want to answer Justice Coriel's question about the time. I don't want to mislead the court. It was not just 5 hours in total over the course of the case. What the father testified to was the longest time he ever spent was a 4-hour visit when the child was 2 and a 4-hour visit when the child was 3. He had 2 more visits in person after that. Okay. That's the extent of the in-person visits with the father.
So the harm part, though, that means all you need to do is look is one of the grounds proven by clear and convincing evidence, and they're just they're different. Some of them involve failing a plan, some of them don't.
Yes, but it's not just looking at just proving just that ground. It's also proving how that ground relates to the child. So we'll take our case from Florida Department of Children and Families versus FL, which was the 2004 case that addressed a prior involuntary termination of parental rights. And this court said we can't just look at that one termination and what happened in that other child's history, which could have been 20 years ago for all we know. We got to look about what is the harm to this particular child. And that is something that the department can live with, because what we're trying to do for these families is we are trying to reunite these families. And so where it is appropriate to do so, where there's not harm in providing a case plan, we offer a case plan. And then if the parent continues to engage in the dangerous behavior, we've got that risk. But where there are some things that are just so harmful that they're deplorable, they're flagrant, they're abandonment, we are establishing that risk to that child, and that's where the constitutional protection is in existence. I see that I've run over my time. Thank you very much.
Thank you.
I just want to leave the court with some language that this court used in TM. When it rejected the constitutional argument, it said, only through these measures, with these measures being the ability to terminate without provision of a case plan, will the court be able to adhere to the overriding principle that it is the ultimate welfare or best interest of the child which must prevail. What that means is, I think the state is exercising its parents' patriotic duty in these cases to protect children. And so this tool, this ability to go without a case plan, is one of the tools in the state's toolbox to be able to not only decrease the harm to the children from the parents' behavior directly, but also to ensure that no child stays in out-of-home care longer than is absolutely necessary, and that we get to permanency as quickly as possible. And all of that feeds into least restrictive means and the ultimate balance between what is fair before terminating parental rights. And so the department, or the guardian ad litem office, would just ask this court again to reverse the opinion of the 5th District Court of Appeal and reinstate the order terminating parental rights so that LA can find permanency after nearly 6 years.
Thank you very much. We'll take a 10-minute recess. Thanks.
All rise. Florida Supreme Court is back in session. Please be seated.
Our last case today is number 15-0391, Herard versus State of Florida.
Mr. Chief Justice, members of the court, may it please the court, my name is Richard Rosenbaum, and I was appointed to represent James Herard in the appeal of his judgment, conviction, and sentence of death. He has raised several arguments on appeal. I'm going to focus on just a couple of those arguments today, primarily the order denying the defendant's motion to suppress multiple statements that he gave to law enforcement, as well as the disallowance of the defense expert concerning false confessions, Dr. DeClue. First of all, with regards to the statements, the defendant was originally arrested after trying to steal a dog. He was taken into custody. The arresting officer or detective came into the facility and asked him if he wanted to waive his Miranda rights. Went through a Miranda form, and he said, "No, I don't agree to that." Unequivocal invocation of his rights. A little bit of time elapsed, and it's hard to tell exactly the time. We've got in front of the court not only the video of the confession, but through a number of supplementations, actually the transcript of what was going on. But at some point, it's alleged that the defendant says, "How long is it going to take for me to have a lawyer come see me?" And then the state would argue he just didn't want to wait. He became anxious, and he started asking questions or talking about the case. We contest that, number one, law enforcement had no justification for reinitiating their contact with the defendant after he had already demanded counsel. Number two. Well,
but he's the one that kind of kept this conversation going. I mean, if you look at it all in context, because he asked him if and he's concerned about having to wait for whatever reason, and they said, "Well, you know, you're going to get booked," they tell him, and then he says, "You want your attorney?" And he says, "I'm too smart for that. I'm good, nah." And then the officer says, "I don't understand what you're saying, sir." And then the defendant says, "I don't want an attorney." That just seems, this is the episode, right?
You're in the correct portion, but he did state, "I don't agree with that." So he was.
We did originally, but then he changed his mind unequivocally. It seems like to me. He said, "No, I don't want an attorney." And they said, "Do you want me to talk or not?" And let me sign it. I want to sign your paperwork. And he says he wants to talk to him. So, and he signed it apparently.
Well, if that's a valid reinitiation, then at that point the defendant has made his choice. Now that's a far cry from like the statement at the end, and I hate to switch between statements, but his statement at the end is made after he goes to court. He has a public defender.
Well, no, when you say the statement, you're not talking about part of this related to this particular statement that you think is inadmissible.
Well, we're talking about 22 hours of statements here.
Okay, you're talking about which one is it? Well, talking about the last one?
This is the last one that occurs after the defendant has been brought to the initial appearance. The officer wants to come up and talk to him again about the dog case. His public defender had been appointed, filed an invocation of right to counsel under the 5th and 6th Amendments, and that afternoon at 6 o'clock in the evening, the detective walks in and says, do you want to give a statement? And the defendant signs Miranda. But that gets around the fact that the defendant's counsel had invoked his right to counsel earlier in the day. So the argument is that the defendant is at the very least entitled to have his lawyer consulted, or he should have.
Now, what were the circumstances of invoking the right to counsel?
Those circumstances where the defendant was brought in front of the court for his initial appearance
On,
on the dog case, on the
Okay.
theft of the dog case.
but this statement's got nothing to do with that. They're talking to him about a matter of greater moment.
Well,
on the dog
there-
case,
and the dog
which
case.
it brings us to this court today, right?
Yes, it does, and unfortunately, it is a death case. But it starts off with the initial arrest being for the dog and the theft of the dog, and the defendant begins by ready to talk about the dog and then says that he doesn't agree to waive his Miranda rights, and then he starts talking. Now, he talks about a number of different Dunkin' Donuts robbery, burglaries. He says makes inconsistent statements. At certain points, he claims that he didn't do it. At other points, he admits that he did do it. This is sort of tied in with the expert witness that the defense wanted to use, Dr. DeClue, that would talk about the Reed technique, which was used by the main officers in this case. The purpose of the Reed technique is to try to get incriminating statements out of defendants, and it's something that was in fact.
Isn't that the purpose of any police interrogation? If they're talking to a suspect?
They're trying to get him to talk about the crime. But these are coercive methods that are used under the Reed technique, really.
Well, one could acknowledge that they're manipulative.
That's probably a very good word for it.
But we don't always equate. I mean, in the law regarding these matters, manipulation is not equivalent to coercion, is it?
No, it's not the same thing, although if there have been promises and more than misrepresentations, here I'm assuming that you're either going to read the transcript or you're going to watch the actual videotape. You could see from the body language that there was some pressure that was being exerted on the defendant. The defendant claimed that he didn't have the ability to go to the restroom, didn't have access to the restroom, and on a couple of occasions was forced to urinate in a McDonald's cup. The law enforcement's perspective is that everything was perfect. We let him go to the bathroom, we let him rest in between these times of interrogation, and that this statement was just like any. But if all statements are under really promises of leniency, then all those statements should be suppressed. Now, I talk about these two statements. The first is the reinitiation. The last one is the invocation of the rights and the fact that the detective just goes on in to take the statement regardless of what's going on in court that morning and regardless of his lawyer's invocation. And the only other portion of the statements that the trial court failed to address whatsoever in its opinion is as the defendant is coming out of the Lauderhill Police Department, he looks around, he sees which officers were there, and he says something to the effect of, "Where's Tamarack and where's Sunrise?" I think I'm getting the cities correct. But law enforcement used that as part of the link, insinuating that the defendant knew where he had committed crimes, saw officers from all these different jurisdictions, but wondered where those two were. Now, it might be as simple as a Rhode Island versus Innis spontaneous statement where the defendant makes those statements after he's looking down the stairs. It may be that this is a statement right after the reinitiation had occurred, and it should be lumped in with that set of statements. The defendant's contention is all along that none of these statements were freely, knowingly, voluntarily made, and obviously the trial court ruled to the contrary.
So on the last set of the last aspect of the questioning after the invocation of rights at the first appearance,
yes,
the state's response on that was that the invocation of counsel is, charge specific. I didn't see you dispute that legal premise in your reply brief. Do you have a response to that?
The case law is that it is case specific, but the detective that went in that last time was asking about the dog burglary or theft of the dog, and it was specific with regards to that portion of the case. Now, the defense lawyers tried to make a good argument that under Wong Sun, the very first time he asked for a lawyer and said, I don't agree to sign the Miranda form, that tainted everything from the dog all the way to the very last robbery murder that was involved in the case. If the court separates the statements into the different incidents, then that last statement wouldn't have anything to do with the statements that were incriminatory with regards to the murders.
Okay, so yeah, remind me about that. So where he finally acknowledges, about, telling the actual shooter, that all happened before this last conversation that you're talking about?
Yes, sir.
Okay. So as to that part of it, your argument would hinge on whether we agree with you on this initial issue of, I don't agree to that, and then whether he reinitiated and whether there was whether there's a knowing waiver and all that.
Not only that, but the issue of what good is it if a lawyer invocates a client's right to counsel and the detective is coming back to talk to the defendant about that very same thing that happened in court? Is that outrageous?
I know, but now
conduct?
are you switching back to the last statement?
I am. And,
all right.
And it's a question of whether it becomes outrageous. And I would argue that if it's some type of outrageous conduct, that then it spills into no longer being a case-specific questioning and answers.
Do you think that statement can stand on its own in terms of constituting reversible error, or would we have to agree with you that all four statements, or all four occasions rather, were violative in order for any one of them to constitute reversible error?
We believe that any one of them rose to reversible error, but we do acknowledge that some of them could be considered harmless, at least with regards to the theft of the dogs. With regards to the other one, no, they went to the very heart of the case, and the defendant's statements were conflicting, basically depending on which officer walked in to take his questions. While he did at some point admit to most of the robberies and all but one of the murders, there was conflicting evidence out of his own mouth. Now, at the same time, the state is proving these things independently by calling the witnesses, the arresting officers, trying to tie in the shotgun that the tall man, who they believed to be James Herard, was ultimately seen using, and each of the crimes where the sawed-off shotgun was used, and those were a direct match. Am I willing to concede that it would only be harmless error? No. We believe that the error went to the very crux of the case. The statement was devastating. I mean, when the statement came in, it was very little likelihood that the defendant would prevail, regardless of any of the other forensic evidence or physical evidence. The statement itself was devastating, and I think the court should pay special attention. Did the state scrupulously honor the defendant's request to have a lawyer or to stop the questioning, to stop the Miranda, because, quote, I don't agree with that.
Right, but what you're calling devastating is not the post-first appearance statement, the fourth of the four.
Correct. Okay. I believe that of the four, that's the most innocuous of them.
Okay.
A major issue that came up in the trial was whether Dr. DeClue, an expert, could come in and testify under 702 and under Daubert, not with regards to whether James Herard was the subject of a false confession here, but to explain the Reid technique and the ways that the officers use it. The court denied the defense request to use that, saying that since the defendant never took the stand and said that his confession was false, that it didn't come into play, and that really the fact that the Reed technique was used was irrelevant to these proceedings. We argue to the contrary, that the way the officers went about their questioning to try to elicit an incriminatory response was something within the purview of the jury, and that they should have been allowed to hear about how the technique works. Not the ultimate conclusion of, James Herard, did you make a false confession or not? But, ladies and gentlemen of the jury, this is how the Reed technique is utilized. This is how Detective Goodwin did it in this case. These are the questions that ask. These fall within the different 9 points in the Reed technique of interrogations. He believes, the defendant believes, that would have impacted greatly the jury's look at his statements, made it maybe quite not as devastating. It wouldn't have changed the words, but in showing law enforcement's motivation and the procedure that they utilized to elicit these incriminating remarks would have shed a better light on the situation. And so we believe that, respectfully, Judge Backman reversibly erred in refusing to allow Dr. DeClude to testify. The doctor did give a full proffer, so that is properly preserved for appellate review. With regards to Mr. Herard's arguments that Section 921.141 is unconstitutional, this court has heard a number of challenges to the constitutionality. Keep in mind, this was an 8-4 decision, pre-Hearst, pre-Poole, and when this case started, it was a totally different standard that I expected to be arguing here in front of the court. Thought I would just come in and argue that because of Hearst, we operated on an unconstitutional statutory scheme, and that the death penalty shouldn't be enforced in a case like this, and that there should be a resentencing proceeding at a very minimum, if not that the court should reimpose or impose a sentence of life imprisonment as a result of the changes in the law. We've set forth our different grounds for unconstitutionality. I know that almost every single Thursday I see cases that come out that talk about one aspect or another of either the jury instructions or the new statute or the even newer statute and the 8-4. So at this point, in light of the state of the law, I will stand on the arguments set forth in my initial brief and the reply briefs and the supplemental brief, unless the court has any questions.
Thank you very much.
Thank you.
May it please the court, Lisa Marie Lerner with the Attorney General's Office for the state. Excuse me. In terms of the motion to suppress, I'm going to divide it into 3 interviews and then his statements in their stairwell. The first interview that Mr. Herard is challenging is the one taken by Detective Williams at the Lauderhill Police Department. That was about the robbery of the dog. Luckily, we have it on video and audio tape, and I took the liberty of going through the tape and watching the timestamp. At exactly 3:57 minutes into the recording, not the interview, but the starting of the recording, Herard says that he doesn't agree with the waiver. They then go through a colloquy with Detective Williams, asking twice during that time, do you want an attorney? At 4:51, 4 minutes and 51 seconds, Herard says he wants to sign the paper and tries to grab the rights form away from her. That's less than a minute. So in less than a minute, Herard said, I don't agree with that, then changed his mind, said, I want an attorney, tried to grab the rights form from the detective, with the detective asking twice, do you want an attorney? That is the situation we have here. Clearly, Herard reinitiated the interview. After the detectives had made ready to stand up, they'd collected their papers and were ready to go. He reinitiated the interview. If this court is concerned with a recent argument done in the Penna case, the state submits that the fact that Detective Williams reminded him that he did not have to talk to her, asked him specifically, do you want an attorney, and then handed him the form for him to review and sign. Essentially, not only did she go through the rights initially less than a minute before, she essentially reminded him of the rights she had just told him and gave him a chance to reconsider, even though he had reinitiated the conversation. The next number of statements come in when Detective Goodwin and another detective are escorting Herard from the Lauderhill interview room down the stairwell into the processing center. And as Herard is walking down the stairs, he sees the Broward Sheriff's Department, and he also police officers, and also sees Sunrise police officers. And Herard says, Sunrise, what's Sunrise doing here? He goes, oh yeah, Sunrise. And then he says, where's Del Rey? Because he didn't see any officers from Del Rey. In Sunrise, Broward, and Del Rey, that's where the Dunkin' Donuts armed robberies occurred. So by those statements, which Herard said spontaneously, without any comments made by either of the detectives, linked himself to the string of armed Dunkin' Donuts robberies. He knew why Sunrise was there, and he was confused why Dunkin' Donuts, where he had shot 3 people, why they weren't there as well. That is clearly admissible under United States and this court's case law. The third interview was the one that I say was essentially conducted by Detective Goodwin with other individuals. That is the interview which lasted approximately 12 to 13 hours. The entire time Herard was in the interview room was taped, and Judge Backman reviewed the entire audio and videotape and watched and made the determination that Herard slept about 6 hours, was given food, was given things to drink, was taken to the bathroom multiple times, and found that there was no coercive behavior. And Judge Backman clearly put that in his order denying the motion to suppress, and the record clearly supports his factual findings, and I believe that he correctly applied the law to those facts in finding that there was no coercive behavior and deny the motion to suppress. The third interview is the one with Detective Visners. That occurred in the evening after Herard was taken to his first appearance for the dog robbery. At the first appearance, an intern with the public defender's office, not an attorney, an intern, filled out a paper saying Herard demands an attorney for this dog robbery charge. That happened about 1 in the afternoon. About 6 in the afternoon, Detective Visners and his partner went to interview Herard at the jail. And it was a jail interview, not a police agency interview, so there was no video equipment available. Herard refused to allow it to be audio taped. Visners went through a Miranda form and had Herard sign each line and said that Herard had no questions, waived each right. Visners read it, Herard read it out loud, and then Herard read it and signed it. It was a complete waiver of Miranda. Visners was a detective from Sunrise Police Department. He had nothing to do with the Lauderhill dog robbery. He was one of the detectives interested in the Dunkin' Donuts string of robberies. From my review of the record, I will let it stand for itself. Detective Visners at no time asked about the Lauderhill dog robbery. He asked extensive questions about the Sunrise Dunkin' Donuts robbery, and then went into the other Dunkin' Donuts robberies. Herard volunteered to draw the various Dunkin' Donuts area locations. Visners gave him paper, allowed him to draw the one in Delray, the one in Tamarack, the one in Sunrise, and to say why they chose these and how they went in and how they went out and how they practiced at home before they did this so it could come out. That is the interview Detective Visners did. He also asked Herard about his gang membership, and Herard was very proud of it and drew out various gang insignia and information voluntarily and gave it to Detective Visners, indicating that he was a member of the Backstreet Crips, coordinated with the West Coast Watts Crips, I believe. That is the third official interview. It does not violate Miranda or any of this court's law and was properly not suppressed.
And is that because of what, the offense-specific aspect, or is that irrelevant in your view because of the, giving Miranda and signing the form and all that?
Both, but specifically because it is case-specific, the invocation for an attorney. And as this court and the U.S. Supreme Court has said, the Fifth Amendment rights and the Sixth Amendment rights, while they coordinate, they do separate. So when someone claims his Sixth Amendment right to have an attorney on a particular case, that is case-specific. When Detective Visners went in there to interview Herard on a separate case, that invocation of his right to an attorney did not go to the Sunrise Dunkin' Donuts. And when Detective Visners gave him a completely new Miranda advisement, that Herard waived any ensuing information during that interview was admissible. And the court did not abuse its discretion by denying the motion to suppress that statement. In terms of the false confession expert, the court below, Judge Backman, said that essentially to have this expert come in and testify about the Reed technique just out in the air without any solidifying it on the facts of this case is essentially having the defense offer an opinion to the jury that the Reed technique creates false confessions and have that idea put in by an expert. And the court found that, one, it was more prejudicial than probative because it was not tied to the case, and it would give the jury the false impression that this expert was saying that this interview, because Detective Goodwin had used the Reed technique, was false. The court also said that this type of expert testimony did not meet the Daubert standards, and Judge Backman specifically went through in several different arguments during the course of this trial, saying why it was not admissible under Daubert, because the theory could not be peer-reviewed and it could not be tested. There was no hypothesis. The expert testified himself that he didn't know how many times the Reed technique produced false confessions or true confessions. He admitted that it was very rare that a false confession came out and could not specify why it occurred in specific instances and not other. And based on the lack of relevance to this case and the facts in this case, given that Herard did not testify saying it was coerced, and the fact that it did not meet the Daubert standards, the court did not allow it under relevancy and that it was more prejudicial than probative. I did want to comment on one other thing. In the first issue, the defense indicates that the court should have granted the motion to dismiss because it had previously stricken the jury panel. I just wanted to note that the motion to dismiss that Mr. Kulik filed was baseless, because if the court goes back and reviews in the supplemental record, it was the defense who asked the court to dismiss the jury panel. It was not the state, it was the defense. And given that the motion to dismiss the charges were baseless, I ask this court to affirm both the sentence and the convictions.
May it please the court. For the reasons I've set forth, the defendant believes in good faith that he has a Fifth and Sixth Amendment issue with regards to the statements. I'm sure this court will go through each of the statements. Noticeably absent from Judge Backman's order on the motion to suppress was anything about the statement that was made as Mr. Herard was walking out of the police station. Where are the other two agencies? So since the state has addressed that, and it is an open issue, it was something that the defense moved for suppression of at the trial court level. It was just something that Judge Backman never addressed. So we would ask the court to address that to the extent that the court can without having to send it back for a ruling.
Address what about it? It's a spontaneous statement without any coercion from the defendant. What's your argument?
If you're making a finding that it's a voluntary statement.
Well, no, I'm not making a finding. I'm saying on the record before us, the defendant made this statement. What is it that is your argument that he made it under some form of coercion? Are you making an argument that the Reed technique continued into the hallway? What's your beef with it?
Well, I can't make that argument in good faith. I think that the problem with it is that it's a statement that the defense sought to suppress. Whether they did so properly or improperly, it hasn't been ruled on.
I mean, you have to have a custodial interrogation, and we got custody.
Yes.
That's no question about that. They got him. But there's no interrogation. He just says it. I mean, my colleague has indicated. There's just nothing to it because there's no interrogation. It's just like on the face of it. And I can understand why a judge might just think that's kind of ridiculous. I mean, it just kind of speaks for itself.
Well, I understand the court saying that. So, I mean, obviously, I take a different position. The defendant's clearly in custody, and any statement that he makes is a custodial interrogation, but there may not be a specific question that was asked.
Well, it might be a statement. A custodial interrogation is not the same as a statement made in custody, okay? You could have the guy in custody in the back of a car after an interrogation, going to the hospital or something like that, or going to another location, and who just pops up and says, I did it, I killed them all, just out of the thin blue, nobody asking him anything. That does happen, that's happened, but that doesn't get suppressed.
It doesn't, and that's why I brought up Rhode Island versus Innis, which is what I believe is probably controlling, although not necessarily exonerative for my client. So based upon the unlawful statements, at least from our perspective, the court's failure to allow the defense expert to testify in the unconstitutionality of the Florida death penalty statute, we urge this court to overturn the 8-4 recommendation and the subsequent sentence of death that was imposed. And we thank you for your time.
Thank you. We're adjourned.